Good afternoon and welcome. My name is Ron Brand. I am a professor at the University of Pittsburgh School of Law, where I am academic director of the Center for International Legal Education. We have been involved in all 15 of the MENA Pre-Moots, and so I welcome everyone to this, the 15th MENA Vis Pre-Moot. We have had a wonderful week of preparation and general arguments, quarterfinals, semifinals, and now we're down to the last two teams. Today's argument, presentation in the arbitration, in the case of Green Hydro PLC and Equatoriana Wind Power Limited. Green Hydro PLC is the plaintiff. Equatoriana Wind Power Limited is the claimant and the respondent. And in this proceeding, the team from New York University, Abu Dhabi, will be representing the claimant, Green Hydro, and the team from Al Faisal University in Riyadh will be representing the respondent, Equatoriana Wind Power. Have counsel for the parties agreed on an order of presentation and time allocation?
Yes, we have. The order that we've agreed on is that respondent will go first for procedure, followed by claimant for procedure, followed by respondent for applicable law, followed by claimant for applicable law. Apologies, can you hear me? Yes. So to repeat, the structure is RC, RC.
Okay. And that is acceptable to counsel for both?
Yes.
Okay. In that case, in accordance with that allocation.
Thank you, Mr. Presiding. We just want to clarify that we're going to commence on the procedural issues, starting with respondent, followed by claimant, both for 14 minutes, and for the applicable law, starting by respondent, followed by claimant for the same time allocation.
So respondent will go first on both of the sets of issues, is
Yes,
that correct?
that is correct.
And that's acceptable to the claimant?
It is indeed.
Okay, are there any other matters that need to come before the tribunal before we begin with the presentations?
Can everybody hear us on the mic? Is it loud enough? Yeah? Okay, this is, okay, perfect, thank you.
Okay, in that case, respondent, you may proceed.
Thank you, Mr. Presiding. Honorable members of the tribunal, esteemed colleagues, good afternoon. My name is Basma Afana, and today, and together with my co-counsel, Ms. Sara Al-Mshari, we appear on behalf of my client, Equatoriana Wind Power. I'll be representing the first two issues, while my co-counsel will be presenting the third and fourth issue. We will hear different submissions from claimant as it tries to represent itself as the burdened party. However, claimant is bringing my client to these proceedings disregarding the fact that mediation is a precondition to arbitration. This will eventually deprive my client's right to mediate. Therefore, two broad submissions will be presented before this tribunal on the procedural issues. Firstly, we request the tribunal to reject the claim for lack of jurisdiction. And secondly, we ask the tribunal to include Exhibit R3 and exclude Exhibit C7. With regards to my first submission, We would like to note that the arbitration agreement present in the purchase and service agreement, the agreements that both claimant and respondent consented to, is governed by the FAI mediation and arbitration rules. Therefore, we will be applying them. If I may point the tribunal to page 12 of the record, Article 30, the dispute resolution clause, and I quote, any dispute, controversy, or claim arising out of or relating to this contract shall first be submitted to mediation in accordance with the mediation rules of the Finland Chamber of Commerce. Continuing to page 13, the fourth line, and I quote, termination or validity thereof shall be finally settled by arbitration. The usage of the mandatory language is very clear and indicates that the parties will only resort to arbitration after they mediate. They didn't only use the word first, they used the word shall finally, indicating that if the parties fail to agree in mediation, then they will proceed to arbitration in the second tier.
Well, counsel, that's all very well and good, but did your client request mediation at any stage?
Thank you for your question. No, my client did not.
Why didn't they? They must have been able to read the provision just as well as the claimants.
Claimant have requested for arbitration. However, my client wants to amicably solve this dispute.
It seems to me that one way we could look at this is that by now appearing before us in arbitration, without requesting mediation, the respondent has waived any right to mediation prior to arbitration. Why should we not look at it that way?
Thank you for your question. In regards to my client waiving its right, the PSA itself, the dispute resolution clause, the multi-tier dispute resolution clause prevails. Therefore, we should adhere to the agreed upon procedures to proceed to mediation before resorting to arbitration.
But counsel, if we take that, at what stage does the mandatory provision get overruled by the process? What happens if the arbitration ran all the way through? Oral hearing, the tribunal say that they will deliver a written final award, and then you say, no, sorry, all of this is irrelevant because there's a mandatory mediation clause. That couldn't possibly be right.
Actually, that is correct. In regards to the enforcement of the award, the construction of the green hydrogen plant is in Equatoriana. Therefore, we would like to the tribunal to take into consideration when rendering the award that we don't want to simply go through the arbitration process to render an arbitration award that would not be enforceable in Equatoriana, where the implementation of the green hydrogen plant is going to be constructed.
Mediation ends only in a consensual resolution, isn't that right? We cannot, there could be no successful mediation without the consent of both parties at the end of that process, isn't that correct?
The parties have consented to arbitration. However,
I'm simply asking a yes or no question.
could you please rephrase?
In order to end the mediation process successfully, the parties both would need to consent to the settlement agreement in the mediation process, isn't that correct?
Yes, that is correct.
Yes, and this in arbitration is not a consensual process. A result can be imposed by a third party, right?
If you could
Isn't it seems to me that the claimant comes before us saying, there is no consent to resolution. We're unable to reach a consensual resolution. we're ready for a non-consensual dispute resolution process. And if we don't consider that to be waiver, could we, a second question along with that, could we not also consider that the fact that we're here to have amended the language in Article 30 of the dispute resolution clause?
The parties have consented to the arbitration agreement in the PSA Article 30, the dispute resolution clause. Therefore, this arbitration agreement in itself prevails. Being conscious of the time allocated, I would like to move on to looking at the intention of the parties when if I may guide the tribunal to Exhibit R2. Page 31 of the record. May I know if the members of the tribunal are with me? An email from Mr. Demon, the head of contracting for claimant, to Ms. Ritter, head of contracted for the respondent, Exhibit R2 on 12 July 2023. The last two sentences of the email, and I quote, "Furthermore, the FAI model mediation clause suggested by us clearly provides that parties must first try to mediate their dispute before resorting to arbitration. Thus, arbitration is only the last resort as you wished." This is an email from claimant consenting to resort only, finally resorting to arbitration if mediation fails.
I might repeat the same question because I still don't think that there was a clear answer for it. So if the claimant and the respondent are very aware that mediation was the first resort, not the last resort, and it had a mandatory language, why didn't the respondent ensure that the mediation process is adhered to?
This is exactly why my client is bringing up this issue, because the parties cannot arbitrate if they have not complied with this multi-tier dispute resolution clause. Actually, the dispute resolution clause itself has a mandatory language. They use the word shall, they use the word finally settled as a consequence. And we looked at the interpretation of the parties, and therefore we can conclude that they have consented to mediation first.
Councillor, is there a difference between the dispute resolution clause, which you've already taken us to, which talks about shall be submitted to mediation, and the form of wording in the paragraph you've just read out, which talks only about must first try to mediate? There's a difference between submission to mediation and trying to mediate. Is it not possible for claimant to say, well, we knew that mediation was going to be futile, so there was no point in trying?
I understand your concern. They have not used the word try, they have used shall first mediate. And regarding the futility of the mediation agreement, this is why we want the parties to mediate first, to bring up the parties and the parties to agree when when in cases of dispute. Being conscious of the time allocated, I would like to move on to my second submission, and we will go over it briefly. The tribunal, we request the tribunal to admit Exhibit R3 and exclude Exhibit C7.
Which one would you like us to consider first?
Exhibit R3, which is in page 32 of the record, an email This is an email that is legally privileged. Moving to page 33 of the record, the right column, the second paragraph. So far, the Nubia has no rules on legal privileges protecting such documents from disclosure.
That gives us some idea of the law in Danubia, Equatorial, and Mediterranean about the question. Can you tell us what the question is, what the legal matter is that we have to decide here in order to determine to admit or exclude claim respondents exhibit R7? What's the question?
The question is whether Exhibit R3 should be admitted or not.
But what's the legal source of the request for exclusion?
The request for exclusion is that under the seat of arbitration, the lex arbitri, the Nubia, which is the Nubia in this case, it is silent on protecting legal privileges.
Is what? Silent on what?
Protecting legal privileges.
But the question is one of lawyer-client privilege, is it not? If there is a lawyer-client privilege for this document, we cannot admit it. If there is no lawyer-client privilege, then we can admit it. Isn't that correct?
There is a difference.
Is that the legal issue that we are addressing here?
I understand your concern. However, being conscious of the time allocated, I would briefly go over this.
No, I'm still asking,
Yeah.
what's the source of the legal rule that we need to apply here to determine whether to admit or exclude?
The main issue is the applicable law. However, to determine
And applicable law on what question?
on the evidence,
What question of evidence?
whether it's admissible or not. I would like to move on to Exhibit C7.
Well, Councillor, before we do, looking at Exhibit R3, this is an internal email by one employee, senior employee of the claimant, to another senior employee of the claimant. Do you have any instructions on how your client, the respondent, obtained this document?
This is questionable, and it is not. There are no clear evidences regarding this matter.
We do have some evidence, page 36 of the record. Sorry. We do have some evidence, page 36 of the record, in the final sentence, final paragraph of Mr. Damon's witness statement, or the last two paragraphs, where he says he's never shown this document, he's never provided this document, he's never dealt with anyone on the respondent's side with regard to this document, and his view is that it must have been secured by illegal means through a breach of the prosecutor's office. And then he rather generously suggests that the only other conceivable option is that someone in his office provided it, but there is no evidence of that, is there? There is clear evidence of state involvement in obtaining documents quite illegally. Why should we not leave R3 completely to one side on the basis that it's been illegally obtained?
This is a witness statement from claimant, and it will remain questionable as there is a high threshold to determine whether it was illegally obtained or not. However,
Excuse me, I think I'm going to go to the question. We're beyond your time now, and we would like to hear a couple of sentences on the other document, but before that, this is not a witness statement. This is an internal document of the other party that seems, and it seems a safe assumption that it could not have been obtained by your client except by illegal means. Does that not place the burden on your client to show that it was obtained by legal means? And If you could answer that just briefly and then move to the other document and tell us why it should be included or excluded.
To answer that briefly, Exhibit R3 depends on, it's a witness statement from claimant. C2 is witness, not R3. C8 is a witness and not R3, and cannot depend on claimant witness. Going briefly and being conscious of the time, we would like to move forward to Exhibit C7.
Yes, and you could just very briefly tell us what our award should say on the question regarding admissibility of C7.
C7 is confidential. We're relying mainly on institutions that both claimant and respondent have consented to. Article 34 FAI arbitration rules, specifically Article 9.2, and we are also relying on the IBA, being conscious that the IBA does not bind the tribunal. However, it is mentioned in the FAI. To conclude, we request the tribunal to reject the claim for lack of jurisdiction and exclude Exhibit C7 and include Exhibit R3 based on the fact that the parties have consented to mediation before arbitration in the PSA, looking at the intention of the parties and the clear wording of the PSA itself. Thank you for your time and consideration.
Thank you, Counsel.
Thank you, Counsel. Counsel for the claimant, we will hear your position on these issues. The respondent has taken 18 minutes and 30 seconds. We will give you the same for your initial presentation.
Good afternoon, our Honorable Tribunal and esteemed colleagues. My name is Inshira Mir, and to my right is my co-counsel, Mr. Timothy Chu. Together, we represent our client, Green Hydro PLC, who is the claimant in these proceedings. Today, I will be addressing the procedural issues, while my co-counsel will be discussing the applicable law. Before we begin, let us consider that an arbitration agreement is consensual. It requires the consent of both parties. This dispute is about honoring the principles of contractual agreement. Mirroring my opposing counsel's submissions, claimant makes the following submissions: that this claim is acceptable and it must be accepted, and that Exhibit C7 must be included and Exhibit R3 must be excluded. To start, let us address the jurisdiction of this case. My opposing counsel states that this tribunal does not have jurisdiction on the concept of condition precedent of mediation. First, let me point you to Article 16 of the Lex Arbitri, which explicitly states that the tribunal has the discretion to judge on its own jurisdiction, thereby reinforcing the principle of competence. Additionally, the arbitration agreement in the PSA also qualifies under Article 7 of the same applicable law. Opposing counsels claim that this tribunal does not have jurisdiction due to the concept of mediation's condition precedent in a multi-tiered dispute resolution clause is not a jurisdictional issue. This is an issue of admissibility, which we can see in cases such as Sierra Leone versus SL Mining Ltd, which leads me on to my next point, which is regarding the...
I think already in your introduction you said that we should be, as a tribunal, following the principles of contractual agreement. And if we, I'll come back to discretion in a moment, but if we look at the terms of Article 30, it's very clear, as in page 12 of the record, there is a pre-requirement for the parties to submit the dispute to mediation. What is unclear about the word shall? Where is there any wriggle room in relation to the word shall? And isn't our discretion circumscribed by the mandatory force in the word shall?
Yes, I understand your question, which leads me perfectly on to my next point, which is regarding the language used in the dispute resolution clause. While claimant does agree that the use of language is very important to consider in terms of understanding the intention of the parties, we must also consider that in this dispute resolution clause, a time frame is not given. Instead, it indicates that this dispute must be finally submitted, and therefore it indicates that it is a resolution mechanism vested within force of, that arbitration is a.
Counsel, I'm curious about that. Why would a timeline make any difference? That doesn't change the words shall first be submitted to mediation. How would a timeline change the intent of the parties on that? First is first, right?
I understand your question, thank you. Although first is indeed a strong word to be used in the dispute resolution clause, it is not indicative of a time frame. Case precedent has indicated to us time and time again that for a multi-tier dispute resolution clause to be considered a precondition, there must be a valid time frame. For instance, in ICC case number 9812, a negotiation period of 120 days was considered to be mandatory. Additionally, there is no applicable law in any of the three jurisdictions that could potentially be applied. Specifically, there's no guidance in the lex arbitri regarding the taking of evidence. Therefore, it is claimant's position that the IBA rules should be used as guidance for the tribunal's discretion on the taking of evidence.
And how do you reconcile that position with the claimant's email to the respondent stating that the mediation will be the first resort and the arbitration will be the last resort for resolving this dispute? And do you have any evidence if the claimant have indeed followed up on that statement with a step to initiate mediation at all or not?
Claimant's position is that it stands by that email. The email's language is that the parties must first try to mediate and that arbitration would only be the last resort, which is exactly what claimant has done. As we can see in PO2 on page 53, clarification 24. Apologies, tribunal, page 55, clarification 24. Is the tribunal with me? We can see that in between claimant's notice to respondent of its intent to arbitrate and its submission of the arbitration request, there was no action by respondent in response. Additionally, if we move to page 15, apologies, page 18, paragraph 15, we can see that there was a personal meeting between Mr. Cavendish and Mr. LaCour in which Mr. LaCour stated that without a further price reduction, the continuation of the project was not an option for the respondent.
Is that a good faith negotiation or is this mediation? On clarification number 18, I believe you were, or page number 18 you were mentioning, right?
Page number 18, paragraph 15 references a personal meeting between Mr. Cavendish and Mr. LaCour, where Mr. LaCour stated the position of the respondent, stating that without a further price reduction, respondent would not want to continue with this project.
Yeah, but how is that mediation?
Mr. Cavendish is the one who initiated the meeting after. The timeline of events must be considered. The Exhibit C7, the notice for termination, was submitted in the notice for termination was submitted on the 29th of February, 2024. After which, Mr. Cavendish and Mr. LaCour had their meeting in early May. After this meeting, Exhibit C7 was submitted, in which respondent states that a further price reduction is the only possible option for the project to continue. After these conversations, claimant then notified respondent of its intent to arbitrate. This notification from claimant was met with inaction by respondent, and therefore claimant was forced to move to arbitration as its last resort.
Well, why was claimant forced to move to arbitration? Because if we go, there are 2 points here, aren't there? If we go back, first of all, to page 31 of the record, Exhibit R2, what your client said, and said very clearly, is the parties. So he's firmly aware that it lies as much in your client's responsibility as it does in the respondent's responsibility to try to mediate. And yet, no steps were taken by the claimant to try to mediate. That's the first point. But the second point, and I think this arises from page 18 of the record, paragraph 15, is that after the without prejudice offer, you considered, or your client considered, that mediation was going to be ineffective. Can you tell us why your client thought that mediation would be ineffective when mediation allows the parties to consider a very wide range of alternatives which simply aren't open in arbitration?
It is important to understand claimant's interest in this dispute resolution. Although, if we are to consider that mediation is a condition precedent, even if we take mediation to be a condition precedent, we must consider that a delay in resolving this dispute would considerably damage any potential recovery for claimant in this dispute. One of the claimant's main objectives with this project was to have it realized by 2026 to have it as a reference for its future business operations. And therefore, it required a dispute resolution process that was time efficient and...
So delay and time concerns in the dispute resolution are important. Is that what your position is?
Yes.
But we've had days, weeks in presenting memoranda and legal argument. We're spending this time on a hearing. Wouldn't it have been much more efficient just to have a day of mediation? And claimant could have done that instead of leading to this result. And so if you're really relying on delay, doesn't that put your own client in a pretty bad position?
It is the claimant's position that mediation is also mutually consensual. It requires both parties' consent. And if there was a deadlock in negotiation, then it is claimant's position that mediation definitely will have been futile as negotiation had already reached a deadlock. Does that answer your question?
I take that as the answer. I think maybe we should proceed now to the question of admission of documents, Ed, so that you have time to deal with that, because you've relied on Exhibit C7, but you can rely on that only if it's in evidence. Is it in evidence? Or should it be in evidence?
Indeed, Exhibit C7 should be in evidence. In their answer to request for arbitration, respondent claims that it is in breach of confidentiality for claimant to include C7. However, this is not applicable as the respondent cites Article 15 of the FAI mediation rules. In the same applicable law, Article 3 states that mediation is only initiated when the request is sent to the Finland Arbitration Institute. As this was never done and mediation was never commenced, this rule is not applicable. Additionally,
But we haven't gone to mediation because claimant skipped it. Can't we not apply the rules that would have applied under the party's own dispute resolution clause, whether when the reason for not going there is your client's action?
Even if we do consider that these rules should apply and that this document was confidential or was in breach of confidentiality, this document is crucially relevant to this case and therefore it must be included. And this is because it sheds light on the merits of the dispute. Following termination, C7 speaks to if the respondent actually intended to terminate and whether or not that termination was lawful.
The question, I don't think, is the relevancy of this document to making your case. It is what is the legal basis of asking to keep this document in evidence and asking to remove R2, is it? Yeah, R2 out of the evidence.
Respondent cites that as it is a without prejudice offer, it is protected by privilege, and it also cites in its answer to request for arbitration that the FI mediation rules are not applicable. If we consider that the confidentiality rules are applicable due to the tribunal's objection to the claimant's inaction for mediation, even if we consider that lack of breach, in cases such as Procter & Gamble versus Unilever, it has been cited that there are exceptions to the without prejudice privilege, and the one that applies to our case is the substantial relevance privilege. And therefore, as it is crucially relevant to the case, it must be included even if we consider that, that this document is confidential. Moving on to the admissibility of Exhibit R3. As it is cited exactly by respondent, and this is, I quote, Exhibit R3 is legally privileged, these are their exact words, and that Danubia has no rules about privilege, it is claimant's position that this document should be protected under attorney-client privilege. Specifically, claimant cites Article 9.4a of the IBA rules.
From the record, as best we can tell, there is an attorney-client privilege for this document under the law of Equatoriana, but not under the law of Danubia or Mediterraneo. Is that correct?
As per the case file, there's no evidence in either one of the three jurisdictions about.
What does the article on page 33 of the record, last paragraph, tell us? It says Danubia has no rules, which means there's no privilege. Equatoriana tends to follow the US approach, which would make this privileged. And then Mediterraneo is comparable to that in Danubia, which has no privilege. So of the three possible applicable laws, two would give it no privilege, and one would give it privilege. Which is the applicable law?
Of the three applicable laws, Equatoriana is the closest. As Equatoriana follows American standards of attorney-client privilege, Equatorianian law should apply. And as in the US, there is attorney-client privilege, there should be attorney-client privilege with regards to this document under Equatorianian jurisdiction as well. Lastly, this document is, as the claimant has stated, as the respondent has stated verbatim, that the procurement of this document is questionable as there is no clear evidence regarding how it was procured. Due to this document's questionable discoverability, this document should not be admitted due to its questionable means of procurement by respondent. And therefore, claimant submits that this tribunal does have jurisdiction, this claim is admissible, Exhibit R3 must be included, and Exhibit R3 must be excluded, and Exhibit C7 must be included. Thank you.
Thank you, counsel. So, respondent, I assume you would like to use your 1 minute for rebuttal.
Thank you, Mr. Presiding. Opposing counsel submitted that negotiations failed, therefore mediation is waived. However, this is incorrect. Negotiations and mediations are not the same, and therefore would not render mediation as futile. Therefore, that we should stick to the PSA, the multi-tier dispute resolution clause, which would prevail over all evidences submitted by opposing counsel. Thank you.
Thank you. Counsel for the claimant?
Claimant's position is that there was a deadlock in negotiation, which speaks to the intent of the parties. It is clear that respondent had no intent to mediate. They did not want to mediate, did not move to mediate, and nothing is stopping them from mediating.
Thank you. That concludes the presentations on the first two issues, one of which is jurisdiction or admissibility. We're not going to rule on jurisdiction before we move forward to determine applicable law. And I understand that the order of presentation will be the same with the respondent beginning. Is that correct?
Yes, that is correct.
Okay. You may proceed.
Thank you so much, honorable members of the tribunal. We are here today because the claimant is attempting to impose a legal framework that was never intended to govern their purchase and service agreement for the parties. This dispute isn't about just simply interpreting legal principles, it's about upholding contractual certainty and party autonomy. My name is Salah Al-Mishari, and I will be representing the respondent in addressing the applicable law issues. Our submissions will be in two parts. Firstly, the CISG does not govern the purchase and service agreement, and secondly, the CISG has been validly excluded from the purchase and service agreement for the parties. Turning to my first submission, the CISG does not govern the purchase and service agreement between the parties. We will delve into this argument with two sub-arguments. Firstly, the purchase and service agreement is outside of the scope of the CISG in accordance to Article 1(1)(a). And secondly, the purchase and service agreement is a mixed contract where the services are preponderant. Turning to my first sub-argument, according to Article 1(1)(a), this convention applies to contracts of sales of goods between parties where their places of business are in different states, where these states are contracting parties. From looking at Article 1(1)(a), we can see that there are three preconditions. Firstly, that it must be a contract. Secondly, that it must be a sale of goods, and that they must be in different states, and these states are contracting states. The respondent acknowledges that claimant's headquarters are in Mediterraneano, and that the respondent's headquarters are in Equatoriano. But we would like to acknowledge that Volta Transformer, the claimant subsidiary, operates in Equatoriano. According to Article 10 of the CISG, in the case of multiple places of business, the place of business can be determined to the place of business where the closest relationship to the contract and its performance.
What is the name of the claimant's subsidiary to which you are referring?
Volta Transformer.
And when this contract was concluded, was Volta a subsidiary of the claimant?
When the contract was concluded, it was not a subsidiary of the claimant. However,
And so is that not important to our determination? Are we not to determine what law applies to a contract? We can't have a contract. Are you saying that if a party to contract engages in different commercial or corporate activity over the course of performance, that changes the applicable law, and it changes whether the CISG applies or not? Can a party unilaterally engage in conduct that changes the applicable law without even discussing it with the other party?
thank you, Mr. Arbitrator, for your question. Our argument is not that the place of business, our argument is that the place of business indicates if the CISG is applicable. By looking at the commentary of the CISG 2016, it can say that the company's reliance on a local entity for crucial business operations establishes it as a place of business under the CISG. Here we can see that Volta Transformer, if I may lead the tribunal to page 4, the purchase and service agreement, paragraph 11, page 4, the request for arbitration, apologies. Request for arbitration, page 4, paragraph 10. We can see here that in the first line, for the hydrogen plant itself, they agreed 100 megawatt plant and the extension option. The claimant was going to sign a contract with Volta Transformer. Volta Transformer here in the third line was in charge of manufacturing 40% of the equalizers and preparing and packaging.
Excuse me, counsel.
Yes.
So what you're saying is that if I contract to get part of the goods from another party, then I have a place of business where that other party, third party is located?
Thank you, Mr. Arbitrator, for your question. Our argument is this is not a third party. This is not a subcontractor. This is a subsidiary of the claimant. And since the crucial business operations were
When did it
operated,
become a subsidiary? What's the date of the contract?
the date of the
And what's the date on which Volta became a subsidiary?
The date of the
claimant?
contract is the 17th of July, 2023, and it was acquired, Volta Transport was acquired on the 25th of August, 2023. I can see that the tribunal is not very convinced with this argument. If you'll allow me, I'd like to move on to my second sub-argument that might convince you. Thank you. The purchase and service agreement is a mixed contract where the services are preponderant. According to Article 3.2 of the CISG,
Council, what was basically at the heart of this contract was the installation of a hydrogen generating plant. What is a hydrogen generating plant if it isn't goods?
Thank you, Mr. Arbitrator, for your question. So firstly, to identify the preponderance, we can look at two different tests. There's the economic value test and there's the essential test. We believe the economic value test is inappropriate to apply here because the core of the agreement isn't just the goods. The respondent wasn't just asking for a 100 megawatt plant. It was asking for a highly functioning plant, and this could only be done with the respondent's patented technology. This technology is service. The goods would be useless without the technology. When applying the essential test, let's look at why the claimant was acquired. The claimant was acquired, and let's look at it through the lens of the respondent. If I may guide the tribunal to page 10 of the purchase and service agreement, paragraph 1, last line. Whereas both Green Hydro and Equatoriana Rem Power are committed to jointly building the plant and making it operational. This plant would not be operational with the same level of efficiency without the patented technology of the claimant, proving that the core of
Doesn't that argument cut both ways? Because without the 100 megawatt plant, all of the other services couldn't be delivered. They'd be delivered in a vacuum. So surely everything else is contingent or dependent on the plant. If you come back to your economic value test, doesn't that mean applying the economic value test sensibly that it is a supply of goods?
Thank you, Tribunal, for your question. So the way that we're looking at it is, we looked at it through the respondent's lens. Let's look at it through the claimant's lens. If I may guide the tribunal to page 3, the request for arbitration, paragraph 5. For the claimant, the realization of the project was of considerable importance. It would have been the opportunity to showcase their technology. The claimant themselves can acknowledge that the reason why they went into this agreement with the respondent is due to the service. Moving forward, if I may guide the tribunal
Just a quick question. You are, according to this test, you are considering the patent as a service rather than
Yes,
a product or a good.
yes.
What is the logic behind that? Isn't it a physical good that is allowing them to provide a part of their commitment under this contract?
Thank you, Ms. Arbitrator, for your question. So it's not that the plant is patented, it's the technology that is. The technology is not a product. The plant comes as a byproduct of this technology. So it is not a tangible good and it is not categorized as a good under the CISG.
But if claimant wanted a proof of concept, surely the proof of concept is an operable plant and not the ancillary services which under this contract go with that plant.
Thank you, Mr. Arbitrator. We keep talking about this contract. If I may guide the tribunal to the purchase and service agreement itself, in page 3, purchase and service agreement, apologies, it is in
Which
page
page?
10. Here it says Equatoriana Run Power, customer, Green Hydro, contractor. The model contract, there was a model contract in Equatoriana that was used to base this contract. This can be seen in page 13 of the PSA, Article 31. This document contains the entire agreement between the parties and is based on the model purchase and sales agreement. This was originally a purchase and sales agreement model contract. They changed it to purchase and service agreement, and then they changed it from buyer and seller to customer and contractor. If the claimant didn't believe that the core of it was service, they wouldn't have changed it.
Counsel, I'm still troubled by your argument because you're asking us to apply Article 3, which distinguishes between goods and services. And you're telling us that we should determine that the preponderant part is services because of the technology involved. It takes technology to create any new product that is a good, does it not?
Yes.
Does that make that any less a good?
This is not what we're here to answer. The question at hand is, does this mixed contract have
Let me
the
ask you
preponderant
this,
part be
if I'm
service?
selling you pharmaceuticals and I've spent $1 billion to create a new vaccine, and I'm selling you the vaccine for $100 per unit, does that make that not a good?
Thank you, Mr. Arbitrator, for your question. This example doesn't apply to this case because this case is different. If you may look at page 11 of the PSA, which you're on, Article 3.
I don't want to look at the facts anymore. I want to know the law. Because it seems to me that's what's important here.
Yes.
You're playing with the law here and trying to use the facts. But what does the precedent, what does CISG Article 3 mean when it distinguishes between goods and services? When we're talking about technology, and that you're trying to insert that in here when we're talking about two things that are not technology, they're goods and they're services. I'm trying to understand how the facts as you're using them fit within the law as you're telling us it is.
The facts as I'm using them, and since we have established multiple examples of how the services are preponderant, the way that we are going about it is that since we've seen...
I'm asking, what is your authority for saying that technology and the value of technology reduces the value of the goods?
Thank you, Mr. Arbitrator. This is not any technology. This is a patented technology that, as a byproduct, the goods are done. And looking at the time that we have allocated, we will be turning to the second submission, which is that the CISG has been validly excluded. Let us paint a picture of the party's intent. Firstly, the claimant concluded 2 contracts based on the former model governing law clause for the model contract of Equatoriana, meaning that the claimant knew of the existence of the governing law clause. If I may guide the tribunal to page 32, PO2, 53, apologies.
What's the page?
53 of the PO2. Paragraph 10. The agreement is governed by the CISG for all issues not regulated by the CISG. The law of Equatoriana shall apply. As the claimant had concluded two contracts with this, they knew of the governing law clause, and by negotiating this new purchase and service agreement and seeing that the clause was not there, they have accepted and understood that it has been excluded. In conclusion, the respondent humbly requests that the tribunal decide that the CISG does not govern the purchase and service agreement and that the CISG has been validly excluded.
Well, counsel, I think we need to look at the latter question in some detail, don't we? We know from page 12, paragraph or Article 23, page 12 of the record, that the governing law is Equatoriana. We know from paragraph or clarification 33 of PO2, page 55, that the preponderant view is that the Equatoriana Civil Code is not mandatory. But going back to the exclusion of the right to terminate at will or to terminate for convenience, that arises in Article 28.2, back on page 12 of the record. Now, the claimant agreed to a 5% contract price deduction for the inclusion of that clause because they wish to exclude your client terminating at will. If we are not with you on the termination for reasons of fundamental breach, then why should we not regard this as bad faith? In that essentially what your client is seeking to do is the very thing that they agreed to exclude and for which claimant paid consideration by a reduction in the purchase price.
Thank you, Mr. Arbitrator. Can I request an extension of the time to be able to answer this last question? Can I be granted? Thank you so much. In regards to understanding if there is an unlawful termination and looking at the merits, at this stage of the proceedings, we will not be looking at the merits. That will be later on. We are looking at if the applicable law is CISG. Thank you.
But that raises another question. It is responded that it's challenged the applicable law. And it seems to me you challenge applicable law only if there is a conflict of laws, which means in order to know why this is even important, we must know what difference it makes, whether the CISG does or does not apply. Can you very quickly state what difference it makes and why the respondent is challenging the application of the CISG, given the comments of my co-arbitrator?
The reason why the application of the CISG is being challenged is due to the threshold of fundamental breach or not. So by allowing the CISG to be applicable, there's a higher threshold for fundamental breach, and by applying Equatorian law, then under Article 7.3.8 of Equatorian law, that any governmental entities can terminate for convenience. Thank you.
Thank you, counsel. Counsel for the claimant, we have given the respondent 17 minutes. We will give you the same. You may proceed.
Esteemed colleagues, Honorable Tribunal, my name is Timothy Chu, and I will be addressing the applicable law issue of the case on behalf of claimant Green Hydro PLC. Contracts are a commitment carefully deliberated upon by the parties. If all parties involved are signatories to a legal instrument that they themselves have created to govern the framework of their transaction, a post-dispute insistence on obfuscating the interpretation of law found within only complicates this dispute resolution process. In light of this, claimant will mirror respondent's arguments and make the following two submissions. Firstly, that the CISG is applicable to the purchase and service agreement, and secondly, that the CISG was not validly excluded. Respondent alleges that the CISG is not applicable because it fails Article 1.1a. Under Article 1.1a, we can see that there are three criterions in order to establish the basic applicability of CISG. Firstly, that there is a sale of goods. Secondly, that the places of business of the parties are in different states. And thirdly, that the states are contracting states to the CISG. It is undisputed in the record that the parties are members of states that are part of contracting states to the CISG. Therefore, we need to consider the place of business of the parties in relation to the contract's performance. This is done so under Article 10A CISG, which considers the place of business of the party that has the closest relationship to the contract and its performance in the circumstance. Sorry.
At the end of the contract, if the contract was completely performed, properly performed, what does the buyer have at the end of the process?
If I'm understanding your question, at the end of this contract, the buyer will have a green hydrogen plant.
Yes, and that plant will be immovable, will it not?
The plant itself is immovable, but the components that make up this plant that are essential to the performance of this plant are movable and have to be delivered, which is reflected in the PSA.
Thank you.
Thank you. Respondent incorrectly alleges that Volta Transformer has to be considered the place of business of claimant in regards to this contract. However, there is consistent scholarly opinion that a sale contract must be attributed solely to the legal person which has concluded it, irrespective of whether subsidiaries, parent or holding companies are connected to the
Counsel, what is the impact of the local content requirement in the contract on the question of applicability under Article 1.1a?
The local content provided in this case is not a majority factor, and therefore the internationality requirement under 1.1a is still satisfied.
What percentage of the goods were local content supplied from Equatoriana?
40%.
40%.
40%.
Okay.
Since Volta Transformer is a subsidiary company, it does not meet the standard required to make it the main place of business for claimant in relation to contract performance. When considering the main place of business considerations, we should look at the negotiations, contractual obligations, and overall management authority in regards to the planning and performance of this contract. When considering these elements, it is clear that Mediterranean is the place of business for claimant that is most closely related to contract and its performance. In fact, the main place of business for corporations is typically understood to be its administrative center, and in procedural order number 2, page 52, paragraph 1, if the tribunal is with me. It states that the administrative centers of the various companies involved are located at their places of registration, that being Mediterranean for claimant and Equatoriana for respondent. In fact, if I may further direct the tribunal to page 19, the termination offer from respondent. Respondent themselves have addressed this correspondence to claimant's Mediterranean office, which indicates their own awareness that it is claimant's Mediterranean office that has the overall management authority in regards to this contract's performance.
May I just ask you about something here? So you were saying that Mediterranean has the majority of the services provided under this contract, right?
I'm saying that Mediterranean has the closest relationship to the contract and its performance in whole, when considering the sum of the contractual obligations as well as the performance.
And the performance of this contract is consistent of services or goods?
That will bring me to my next point, which is respondent's allegation that CISG is not applicable due to failing Article 3.2 of CISG. Under Article 3.2, as respondent correctly mentions, there are two tests that have to be considered to see whether or not the contract is primarily a services or sales agreement, that being the economic value test as well as the essentiality test. Pursuant to Advisory Council Opinion Number 4.
Sorry, in that regard, Council, when Mr. Presiding Arbitrator asked you what the buyer would get, your answer was limited to a plant. But if we go back to the purchase and service agreement, straddling pages 10 and 11, foot of page 10 of the record, the contractor agrees, point 1, to deliver the plant. For present purposes, we can skip over points 2 and 3, and quite separate and distinct is a separate obligation to provide maintenance and training services as agreed in detail in Annex 4. So it isn't just the plant that you have to address, and isn't that material in evaluating the Article 3, subparagraph 2 point that you're coming on to?
You are correct. Claimant is not disputing the fact that services are involved in this contract. However, pursuant to our Advisory Council Opinion Number 4, the burden of proof is on the respondent to show that services are the preponderant element. Respondent has not done so under either the economic value test nor the essentiality test. If I may refer the tribunal to page 17, paragraph 11, and refer to the chart seen on that page. Under the highlighted sections, which procedural order number 2 clarifies are to be considered the delivery of goods, the economic value of these elements constitute 190 million euros out of a total of 300 million, which forms over 50%, which is the standard needed to prove preponderance under the economic value test. However, even if the tribunal may find that such calculations in the chart prove to be inconclusive, the essentiality test still favors claimant's position because, as the tribunal rightfully pointed out, these services are contingent upon the delivery of a plant, for there would be no training and management required if the green hydrogen plant was not delivered in the first place.
I have a follow-up question on that argument. If the goods were delivered but not assembled by the laborers and workers in the element of the construction part of the plant, will your products or will the delivery of the product be essential for the fulfillment under this contract, excluding the training that is subsequent to the delivery of the plant? So is the plant going to be operational if only delivery of goods were done without the element of construction to the plant?
No, the components themselves would not make the plant operational. However, we must still view this in light of the economic value test, which weighs both of them together.
Is the economic value test the only test we can apply in determining our award, or can we choose to apply a test based upon the essential elements of the contract?
Yes, the tribunal can also apply the essential test, as I've pointed out. However, the economic value test should be the primary test, according to scholars. Does that answer your question? Thank you.
Well, Councillor, if we look at the economic value test and we think that it's fairly evenly balanced, and we go on to the essentiality test, just because I put 1 point to one council doesn't mean that I can't put the equal and opposite point to you. And the point that I would put to you really arises from this clear splitting out and separation of the plant and the services. We know that this was a proof of concept by your clients. They wanted to have something which was new and innovative. and therefore surely in the context of something which is new and innovative, both maintenance and training are a very top priority in relation to the essentiality test.
That is correct. However, the maintenance and services found in the PSA constitute only 1 year. If respondent really valued these elements, it would probably extend for a much longer duration. Furthermore, as indicated in the record, respondent chose claimant as its to award the final award of the bid because claimant was in a position to already deliver the transformers. This was a very important consideration for respondent. Therefore, the existence of these goods from claimant was a primary consideration for respondent. Moving on to my second submission, that the CISG was not validly excluded. Respondent alleges that the parties have agreed to validly exclude the CISG based on the changes to the model contract pursuant to Article 29 of the PSA. Article 6 of the CISG does allow for the exclusion of CISG, but this has to be understood within the context of the Article 8 reasonable person test. And furthermore, in Advisory Council Opinion 16, it sets forth the standard that there should be a manifest, clear, and real intent to exclude the CISG's applicability. Under this opinion, the explicit exclusion method is the preferred way of excluding the CISG and is the primary one that should be considered to show the intent of the parties. There has been no explicit exclusion of the CISG under Article 29 of the PSA, since it does not name any explicit law other than the national law of Equatoriana. And since Equatoriana is a contracting state of the CISG is part of the national law of Equatoriana.
Council, if we look at Article 29, which is the place that there would be an exclusion, correct? If there is an exclusion.
Yes, however,
do you agree with me on that? If the parties were to exclude in the contract the CISG, it would be done in the governing law clause. Is that correct?
yes, we agree.
And if the governing law clause says the agreement is governed by the law of Equatoriana, what would the result be?
That the CISG applies.
Yes. Now, a basic rule of contract construction is words that are included have to have meaning, but there are words included after that, right? To the exclusion of its conflict of laws principles. What's the effect of that clause?
The effect of this clause is that it does not exclude the CISG, as this wording does not reference any explicit law displacing the CISG, and furthermore, the CISG is already part of the law of Equatoriana and is not separate.
You've just argued that Article 11A makes the CISG the applicable law. Does that not make Article 11A conflict of laws principles of all of the 3 states here involved who are contracting states to the CISG? You've argued that Article 11A is an applicable law rule. Now you are arguing, it seems to me, that it's not, because if it is, then the words to the exclusion of the conflict of laws principles exclude Article 11A, which is the only path into the CISG and necessarily therefore excludes the CISG. Can you explain why that's not the result we should reach?
Article 11A is not a conflict of laws or applicable law matter, because the CISG is a self-executing agreement and is not contingent upon other things being reached.
Why does the CISG apply in your first argument?
In my first submission, or?
In your first argument, you told us why the CISG is the default law. Now you're telling us why the parties have not excluded it, right? If I remember your first argument, it relied entirely upon Article 11A of the CISG in order to tell us that the CISG is the applicable law. Why does that not make Article 11A an applicable law rule? Which is then excluded by express statement in the contract, which results in the full exclusion of the CISG, because we can't get there from here.
The exclusion of conflict of laws principles is not an explicit exclusion of Article 11A. It does not name that, and it does not name any such specific law displacing it.
Why? And why is that statement not inconsistent with your argument on the first issue that you addressed?
The fact that it is unclear and ambiguous is on the burden of respondent, who was the one that drafted the governing law clause. However, its inclusion does not exclude the CISG because, as stated before, the CISG is already part of the national law of Equatoriana, which is supported by case law, where, such as the Paprika powder case, in which the Austrian court upheld CISG applicability despite a domestic law clause because there was no explicit exclusion.
Well, Council, you rely on lack of clarity and ambiguity, but is there really any lack of clarity or ambiguity here? Because what Mr. Presiding Arbitrator was putting to you was essentially that the CISG is a set of legal principles. Equatoriana law is another set of legal principles. They are not the same. Therefore, there is conflict. And if Article 29 says that the agreement is governed by the law of Equatoriana to the exclusion of anything in conflict with the law of Equatoriana, why does that not have the effect of excluding the CISG? It might not have been intentional, but I don't see any lack of clarity or ambiguity if the tribunal were minded to follow the analysis I've just outlined.
It is claimant's position that the CISG and Equatorianian national law are not distinct elements, but rather part and parcel, because Equatoriana is a contracting state to the CISG. However, in light of time considerations, I would like to move on to my final point.
Yeah, we've already given you more time than opposing counsel, so if you could simply wrap up and conclude, I would appreciate it.
To conclude, claimant asked the tribunal to rule that the CISG is applicable to the PSA pursuant to Article 1, and that parties have not validly excluded the CISG from the PSA under Article 6 and Article 8 reasonable person test. That is all for claimant submission. Thank you.
Thank you, counsel. Okay, and respondent, you have your 1 minute for rebuttal.
Council has stated that the governing law clause is ambiguous and unclear. However, according to Advisory Council, CISG Advisory Council 16, courts and tribunals Council 16, the parties clearly, if the parties clearly indicate their intention to replace the governing law clause with a specified domestic law, then the CISG does not apply, which can be seen in this case. Thank you.
Claimant, your minute.
As stated before, there is no explicit wording in this clause, and under the reasonable person test, this was not communicated to claimant at all. Claimant was under a legitimate understanding that the CISG was applicable because of the gold standard belief, which was communicated to respondent, and respondent did not clarify this point. Thank you.
Thank you. I would at this point ask if counsel for either party has any concerns with the way in which the proceedings have been administered in this hearing.
No, Mr. Presiding, thank you.
Claimant also does not have any.
Okay, thank you. With that, then, the hearing is closed, and I think it's appropriate for everyone in the room to express their thanks for a wonderful The next item in the agenda is the awards ceremony. We're going to take, I think, a brief break so that you may remain in the room and relax. The tribunal will retire to deliberate and return. And Robbie will entertain you in the meantime.
Please stay here. The tribunal can take a moment to deliberate. We'll come back to the awards. Of course, if you use the restroom, that kind of is fine. But we're going to be doing the award ceremony here, so stay very close by and come and stay